Hello everyone, welcome to Redbus US channel. DHS published the final version of the rule, strengthen H1B rule just now today in Federal Register. They have done significant changes. In this video, we'll cover all those aspects. If you haven't subscribed, do subscribe to our channel for getting regular updates. So here is what we will cover in the entire article, like, the background, what are the changes coming in, and we look at each of them in detail so that you have a clear understanding of what's coming up. So the first one is, this is the rule, this is the news, right? So as you can see, it just got published October 8th, and this currently is in comment period for 60 days. Now, it's important to understand the background, why they are doing this. So President Trump has been talking about, American first, and in the form of he passed many executive orders. One of the first ones was Buy American, Hire American, that came in some time ago. So that's one of the reasons. And this part of basically the rule. It's about 147 pages, and they give all of these as a background, like H1B program has displaced US workers, they reduced the wages, and also there's a recent proclamation by President Trump that suspended H1B workers entry, and then they want to improve the integrity of the H1B program. Again, this is not new. This strengthen H1B program rule has been there on the agenda for quite some time. It's just the timing of the election, everything has pushed this through. So they also provide some stats that 71% of H1B petitions that are in it are actually involving a third-party workers, which is where a lot of fraud happens. And they have received so many complaints on that. And also they say that the IT wage is pretty much stagnant. In 2003, it was about 189% of national average, and now it's 182%. So which is basically contracting in some way. So this is whatever stat they provided, right? So these are some of the reasons what they say for making these big changes. And they also say that there are about 583,000 H1B workers as per USCIS as of September 2019. So based on all of these, they have done these changes. So these are a snapshot of all the changes, like, they're changing the definition, special to occupation, employer-employee relationship. So we'll look at each of these in detail. So this is just like a snapshot of what's coming up in the next parts. So the first one is the change in special to occupation definition. So the reason for this change is because H1B is as per the Congress statute, which is nothing but the rule, or whatever the law that Congress passed. H1B is treated as a special to occupation, meaning that they expect that somebody who's doing H1B job has really specialized skills in a particular area. And they don't believe that somebody having a general degree in something is considered a special to occupation. So that's why what they're doing is they're changing the requirement and placing emphasis on bachelor's or higher degree in special to occupation, in that particular area. So you just cannot have a general bachelor's degree and work in a special to occupation. Yeah. So we'll look at an example later, but this is the rule text. As you can see, the portions highlighted in yellow directly related to the specific specialty. For example, let's say you're a doctor. You should have a degree in a medicine, so which is so just having a business administration degree or some general degree, you can't claim that an expert in that particular area. So that's what they say. And so the logic or rationale is that this is what exactly is part of the rule, right? They say if you're a doctor, you get a degree in medicine. If you're a lawyer, you get a degree in law. So it's pretty obvious, right? So for special to occupation as well, if you're going to be a programmer or a software developer, then you should also get a degree in something that's related to computers, maybe computer science degree. You can't just have a general engineering degree or a history degree and then become a software developer. Yeah. So this is what they give as an example. And so this is what the requirement, as you can see from the regulation text, you need to satisfy at least one of them. And all of them, if you see the highlighted parts, directly related to specialty, directly related to specific specialty. So all of them emphasizes that part. Yeah. And they also say that the duties should be specialized and again equivalent. So some of the ways, the challenges are, like for example, if you have a degree in mechanical and you want to work in a software engineering or software developer kind of role, so it's going to be, you need to provide evidence that your degree related to that or some coursework related to that. So equivalent, that's what they say. You need to have something equivalent. So this is how attorneys have actually traditionally, supported this, that this person has done XYZ coursework and he has done the skills, or acquired by experience. Yeah. Now the second one, the big change is employer relationship requirements. Yeah. So if you look at it, DH has actually changed their guidance, clause, and they lost in the court. Yeah, they lost in the court, earlier this year. Basically, they lost in the court against IT Serve, and they basically scrapped two of the big memos from 2010, Neufeld memo and other memo from 2018. And eventually, now again, they're kind of bringing back what they actually scraped basically. What they're saying is, instead of saying, these are the XYZ rules, they're saying they're going to follow the traditional, conventional master-server relationship, and they give explanation about, how it's in Supreme Court, some case, telling that the person who hires has right to control that person so that he can get whatever he wants for building the product or task. So this is what they say, and there is no set of standard rules as per them, because it's very hard to say that the relationship exists just by putting some rules. But again, they'll give some guidelines, but the idea is they said they will look at it holistically. And here are some examples, as you can see on the regulation text, right, screenshot. Somebody who can hire, pay, and has ability to fire the beneficiary, who can claim them for tax purposes, who evaluates the work, who's directly linked to the business, and so all of these, you can read through these, right? But the idea is they look at it as a holistically rather than just one part of it, and they're going to look at this very closely in third party placement scenarios, right? Because again, if you look at the history, they have had a Neufeld memo which is from 2010. That's pretty much the same thing we had for a while, and they just changed the wording, and it's back on the table, rather, I would say. So also one important thing is they say that there have been a lot of fraudulent H1B petitions filed telling that there is special to occupation, even though there is no special to occupation work. So there has been some fraud done there. So they say that when you file for a H1B job, there should be a bona fide or basically a genuine special to occupation job for the H1B worker. So this one has to be there. And second one is, if it's a third party workers, they want to actually look at all the documents. So this is nothing new. This has been there, and this was actually scrapped for some time, as per that court case. But again, it's back on the table. So they say that you can submit master service agreements, work orders, statement of work, supplier agreements, any legally binding agreements, client letters, any technical documentation like milestone tables, brochures, funding documents, all sorts of documents, right? So these are typically that used to be submitted by third party for third party placement workers. So this is back on the table. So here is what the regulation text says, right? One or more third party workers, evidence such as contracts, work orders, all of these. So this is not new. It's kind of coming back, I would say. So now you need to make sure you have a client letter, and they're going to look at closely all of those aspects, and they will ensure that you're working in a special to occupation kind of work. Now, one of the biggest changes that they've done is they're going to set the 1 year maximum validity for H1B petitions that are filed as third-party worksite petitions. So what it means is, let's say you are working for an MNC or an outsourcing company, and you're working at a client side, then they will only give 1 year of H1B validity. Even though as per regulation in general law, you can get up to 3 years, they're going to limit that for until 1 year only, for only 1 year, if it's going to be a third-party placement. So the reason for that, they say, is it's a lot of fraud involved and all, and that's the reason they're doing this. So they say there is a lot of cost involved and everything, but bottom line is they're just putting this rule out there. And if you, let's say, continue the same role after 1 year, you can reuse the valid LCA, or you can get a new LCA. And so one of their key points that they say is, okay, usually third-party contracts are 6 months and or less than a year, like all the agreements that are done. So there is no reason for them to actually give for 3 years, because there is so much of fraud that somebody would submit a contract for only 6 months and then the person is working on something else. So what they say is, if we give only 1 year limit, then we can reduce fraud and the employers will be compliant. They will actually submit the latest documentation and latest everything. Yeah. So that's why they're going with this rule. So again, this is the regulation text that you can see, third-party worksite, maximum validity period for approved for 1 year. Again, there are a couple of small things I would say. In the past, they were not giving detailed explanation of why the end date was reduced, or it's shorter than the requested 3 years. So they will give a brief explanation. This is what the regulation text says. The second one is they had itinerary requirement, basically providing day-to-day activities for XYZ months or years, right? Whatever they were asking. Now they say that they explicitly put that this paragraph of itinerary telling that where the person will be and what the person will be doing on a day-to-day basis, this is not applicable to H1B petitions anymore. Yeah. So that's what you can see on the screenshot as well. Now, the biggest change also comes in terms of site visits. So in the past, so there seems to be issues with getting site visits properly done, and there was some refusal to cooperate. Now they say that DHS can conduct inspections over phone, electronically, or you can visit the site, and they can do it before the approval or after the approval. So in the past, there was no concept of doing before. Now they can do even before they approve it, right? Or also after that, right? And one of the things that they added is, they can even go to headquarters of where the H1B employer is, or the satellite location, or where the third party work site is. So this is something definitely new, and they extended the scope of it by a big margin. So as you can see, these are all the regulations, regulatory text screenshot, highlighted in yellow, exactly what we just said. If they say that, if they feel that they cannot verify or they can, if the employer does not cooperate, or the failure by the third party worksite party to cooperate, then basically DHS can deny or revoke the H1B petition, or that's what they say. So revocation is something that happens after. Denial is for something that happens before, like if you are just it's in process. So it's very, very important, and a quite serious thing now. It's not like you can just run away with it. You need to have it have full cooperation from all the teams, and otherwise they can revoke or deny. Now, the other reason is why they're doing this without the rulemaking process. Rulemaking process is pretty long. It takes anywhere a few months, or much longer than that. And it's about 9 steps. So they say that due to the gravity of the situation with the COVID, there is a lot of unemployment, and the volume of H1B workers is quite high. So that's the reason we're doing it. And again, these are all directions of a president. So that's why we're doing it. That's what the statement they say. And they say that, okay, we will look at the feedback, and this can change in the next 60 days because it's not effective on the day it's published, because it's a major rule. Now, who does it apply to, right? So this is another important aspect. So it's effective 60 days from today, and it is published on Federal Register today, October 8th. So it will be effective from December the 6th. That is when it will be effective, and it applies to anyone that have filed on or after the effective date. So essentially, if you filed anything after December 6th, it's applicable to you. So it applies to new H1Bs, extensions, transfers, amendments, everything that you can think of. Yeah. What it does not apply to is anything that's currently pending H1B petitions, right? So, or previously approved, either by, if somebody reopened it and approved it, it doesn't apply to that. Otherwise, it basically applies to all the new petitions. Now that we know all of these, right, will there be lawsuit? Because these are some big changes, right? So, it's very likely, because some of the changes are pretty big, So if you look at the fact of software engineers, in the industry, if you go to Google and look at the backgrounds, so many of them don't have a degree in computer science. Some of them are history majors, some of them math majors or arts majors. They're doing very well as software engineers. So this is something that, that would be, could be litigated. And 1-year approvals is going to be really squeezed all these outsourcing companies. It's going to be a huge expense for them, because they need to pay every time $4,000 extra, and it's going to really cause them problems. So this one may also be contested. So also they got waiver from OIRA, this for the getting analysis and all of that from financial perspective. So this also could be a point they'll contest, and it's passed by a secretary who's not properly appointed. So this is one of the points that they've used in the past as well. So based on all of these things, they could go one or more. So it's very likely we'll have a lawsuit. Again, we'll see what happens in the next 60 days. We'll keep you posted. So that's about it, folks. Hope you all got a good idea. Do subscribe for getting regular updates. Thank you for watching.